Case, please.
State of Tennessee versus $133,429 in U.S. currency seized from Joni, Kilenton et al.
Good morning. Good morning. I guess we're ready, gentlemen.
Before I begin, I'd like to reserve 5 minutes for rebuttal, Your Honor.
5 minutes, all right, sir. You may proceed.
Good morning, members of this honorable court. My name is Logan Wyatt, and along with my co-counsel, Attorney Coleman Garrett, I represent the respondent appellant, Joni Assefa Kilenton. We are here today to request that the funds seized from Mr. Kilenton be returned to him, as the state of Tennessee has failed to show by a preponderance of the evidence that the seized funds, the $105,000 the state seized, were obtained from criminal activity on the part of Mr. Kilenton. Your Honors, this is the second appeal of the forfeiture judgment of the Circuit Court of Fayette County, which this court has heard granting forfeiture of Mr. Kilenton's funds. For reasons which are relevant to this appeal.
Ask you a question. I couldn't tell from what we've seen thus far. We haven't looked at the entire record, but was your client charged in this case?
No, Your Honor.
Was anyone charged?
No, Your Honor.
Is that criteria required? Is there a charge required for forfeiture, or is it not required? What is
Well, in this court's previous examination of the first forfeiture order, this court said that the trial court failed to provide a link proving criminal activity on the part of Mr. Kilenton that would explain and justify the seizure. We're here again looking at this, and the court has not come up, the trial court has not shown any new evidence that justifies the seizure. There have been no charges that the court pointed to.
But is that a requirement?
that was my follow-up. Is that a requirement for the forfeiture?
No, conviction is not a requirement.
It's charging, not conviction.
Yeah,
It's charging a requirement.
No, Your Honor, charging is also not a requirement, but it is instructive to note that he has not been charged, not been convicted. He has no criminal record, Mr. Kilenton. There is nothing in the record that links him to any drug sales, drug theft, drug purchases, and the $105,000, nothing has been shown that shows a correlation between that money, which was found in the passenger area of the vehicle, and the promethazine, which was found in the trunk. Again, Mr. Kilenton operates a transport business that is in good standing in at the place of its founding, which is Washington, D.C., and was on its way to California, where he had his business registered and rental property purchased. The funds that were seized were meant to be put forward to establishing and furthering that new business venture in California. And the state proffered no evidence that shows that the funds taken were the source of, or sourced from any illegal activity.
Did the trial court find that Mr. Kilenton's statements as to what you just basically summarized, what he intended to do with those funds and what was going to transpire with those funds, did the court make a finding that his testimony on that was not credible?
The court found his testimony to be not credible, but the court did not point to any positive evidence put forward by the state that showed an illegal sourcing of the funds. And there are some things that the court did not deny the veracity of. The court stated that Mr. Kilenton was a productive entrepreneur and established a business as a limousine driver and transport business owner. Those are the words of the Fayette County Circuit Court. in its first forfeiture order, admitting that he is a productive entrepreneur and established a business. It's not in any dispute, and it is a matter and a part of the record that his business has a certificate of good standing in Washington, D.C. That's been submitted into evidence. He had insurance policies on the Cadillac Escalades he drove for his premium transport service, which is also in the record. He provided proof of income and disclosed his banking information, specifically his Chase business account for the year 2020. That's on the record, and it shows total deposits of that year in excess of $400,000. He also showed his personal account, which showed an additional income of in excess of $100,000. So the court,
You're referencing the prior findings, aren't you?
yes, these are the findings that were submitted and are evidence, submitted as evidence in the forfeiture hearing and are part of the record now.
Okay, so that was part of the prior appeal, though, correct?
Yes, Your Honor, and
So
those
The only
weren't,
thing
sorry.
we're really looking at today is what we said was missing as a result of the court's prior order. All that other stuff's already been established, right?
Yes, Your Honor.
Okay, so we vacated and said you need to establish the relationship here, essentially.
Your Honor.
Is that right?
Yes, and I can quote from this court. The trial court does not list or discuss any specific evidence presented by the state in furtherance of its forfeiture petition, other than noting the following. It appears to the court that the $133,000 was seized after being found in a vehicle after a traffic stop. The money was found wrapped and boxed in the vehicle along with illegal drugs. While the state may certainly prove its case by circumstantial evidence, what is missing from the trial court's order is a link connecting the facts to any criminal activity on Mr. Kilenton's part that was the source of the seized funds. And to be clear, nothing in this case has changed since the Court of Appeals issued that opinion. The Circuit Court of Fayette County has failed to provide any link connecting the facts of the case to any criminal activity on Mr. Kilenton's part in its latest forfeiture order on this matter. It provides no new findings specifying how the seized currency was obtained through a violation of the criminal code on the part of Mr. Kilenton. Now, to be fair, the court relies on the very same facts to claim a violation of the Tennessee Code, which it did not claim in its original forfeiture. It claims a violation of TCA 3917-417. But the circuit court reaches this conclusion without citing any evidence, as we previously discussed, by the state to support it. It claims a statute violation, but there are no current criminal convictions. There are no charges being brought. The state didn't cite any charges.
You said that's not a requirement, correct?
It's not a requirement, Your Honor, but there needs to be some link, a showing of criminal activity, something that Mr. Kilenton did to obtain this $105,000. And all the trial court has pointed to is, well, the fact that it was in the vehicle, the money was in the vehicle, and in the trunk there was promethazine, which is something that this court has already recognized by saying, as I quoted, that what is missing, and that is not enough. This court acknowledged that.
Well, in the third paragraph, the court says, this court finds that Mr. Kilenton, as well as the operator of the vehicle, were illegally transporting controlled substances as found under Tennessee Code annotated 3917-417, and committed or attempted to commit their illegal acts for financial gain. Is that not a finding?
It's a finding, Your Honor, but it's not supported by any fact. And I think the evidence preponderates against it because the state presented no...
Is there a transcript of the evidence?
Well, what we have, Your Honor, is both of the orders of the trial court which state the evidence they used.
Was there an evidentiary hearing conducted at some point in time?
Yes, Your Honor.
And is that a part of our record?
There is a recording of that is not part of the record, Your Honor. We have all of the evidence which was presented there.
So is there a statement of the evidence then?
On the part of the trial court?
On the part of the parties submitting a statement of the evidence or a transcript?
Yes, there is in the record.
I'm sorry?
There is a statement of evidence in the record, and it does not list any charges against Mr. Kilenton. No proof that the money was earned through sale, theft, or purchase of illegal drugs. And what was shown on the record was proof of a legitimate business, which the trial court acknowledged, a thriving business that showed proof of expansion into Los Angeles County, and a failure of the trial court to show a link of criminal activity to explain an illegal sourcing of the funds. Thank you.
All right, thank you. You've got your rebuttal time. We'll hear from the appellee.
Good morning, Your Honors, and may it please the court. Alan Groves on behalf of the state. This court should either dismiss the appeal for inadequate briefing or affirm the trial court's forfeiture order. The state proved by a preponderance of the evidence that the seized currency was likely derived from illegal drug trafficking. So first, the state has identified several deficiencies in the appellant's brief, none of which were remedied or cured by the filing of a reply brief. I don't think the appellant has addressed any of those deficiencies at an oral argument this morning either. I'm not going to belabor that point too much, but I do want to emphasize the lack of appropriate citations to the record. In this case, I believe the appellant has 12 purported citations to the record in the entire brief, all of which appear in the statement of the facts. And those citations appear to be references to exhibits that were appended to his brief in the prior appeal. And so while the rules of appellate procedure allow you to cite to an appendix in your brief, it doesn't allow you to cite to exhibits attached to briefs and other appeals. He even asked this court to take judicial notice of that prior appellate record, but this court, before oral argument, denied that request because his motion failed to comply with the rules of appellate procedure. And so this court has held that not citing to the record, it's not just a mere technicality, because it seriously undermines this court's ability to conduct a de novo review of the record. And that's especially important in this case, where the appellant seems to be suggesting that the trial court's order is, again, insufficient to enable meaningful appellate review. And if that's the case, this court has to choose between either remanding the case again to the trial court or conducting a de novo review of the record to determine where the preponderance of the evidence lies. And without...
What is in the record? Do we have a statement of the evidence? Do
Yes,
we have
Your
a
Honor.
transcript?
Yes, Your Honor, there is a statement of the evidence. It's not cited very much in the appellant's brief.
Is it the statement of the evidence from the prior appeal, or is it a new statement of the evidence?
There's actually both. I believe the trial court adopted a new statement of the evidence that basically adopted verbatim the prior statement. And I think it's actually in the record twice, in different volumes of the appellate record.
Is there anything in addition to what we had in the prior appeal?
The trial court did not reopen
in
the
the new
proof.
statement of evidence?
No. No, it's the same statement of the evidence. And the trial court didn't reopen proof on remand, so we're dealing with the same set of
So
facts.
you've got the same statement of the evidence, you just have a amended conclusions of law? Would that be accurate?
Yes, the trial court entered a second forfeiture order that complied with Rule 58 with a certificate of service and then made additional factual findings.
Okay.
And so if this court does reach the merits of this appeal, it should affirm the forfeiture order because the state did prove by preponderance of the evidence that the seized currency was likely derived from illegal drug trafficking, which is what the trial court specifically found in its second order. As opposing counsel mentioned, it identified TCA 3917-417 as the underlying criminal activity here. So the trial court was required to apply a totality of the circumstances test when it's determining whether the seized currency was proceeds from prior criminal activity. And in our brief, we've identified several factors and circumstances that support the trial court's decision in this case. We had the driver and the appellant's suspicious behavior immediately before getting pulled over. The driver immediately slowed down when the officer pulled behind him. The officer noticed that the appellant had a pretty nervous demeanor and was having trouble controlling his breathing pattern, which is indicative of a consciousness of guilt. The travel arrangements of both the driver and the appellant were suspicious. Although they had rented this vehicle for about a month, the driver was only had a backpack with him, and the rental agreement didn't list either the driver or the appellant on the rental agreement, which Officer Hill testified at the forfeiture hearing was indicative of drug trafficking when there's a third-party renter that's not on site. You also had the destination of Los Angeles being a source city for drug trafficking, as Officer Hill testified. You had false and misleading statements by both the driver and the appellant. At first, the driver did not admit that he was actually employed as a driver, as an independent contractor of sorts for the appellant. He just said he was going to California to visit friends. Later, he admitted that he actually was employed as a driver. And then the appellant, at the scene, he told the officer that he was not aware of any large amounts of currency in the vehicle, which he later obviously contradicted and now is asserting that $105,000 of that money belonged to him. The amount of the currency itself is suggestive of criminal activity. As we've cited cases, there's plenty of cases holding that most ordinary people conducting lawful activities are not carrying around that amount of money on their persons. And the location of the currency itself also suggests criminal activity. It was concealed in two different locations. There was $27,000 that was wrapped in gold foil on the floorboard of the third row seat of the Yukon, and then the $105,000 was hidden behind some cases of beer in the rear cargo area. And it was also similarly packaged with the cardboard box of 21 pints of promethazine with codeine. So that similar packaging and the concealment and proximity of the currency to the controlled substances further illustrates a connection to criminal activity. But in addition, when officers seized this currency, they had a drug sniffing dog, a canine, that positively alerted to the odor of narcotics on the currency, which strongly suggests that this currency was in the presence of narcotics previously. And Judge McGee, as you mentioned, the trial court in its previous forfeiture order repeatedly discredited the appellant's testimony. And I think there was some suggestion in the last appeal that perhaps the trial court was improperly shifting the burden of proof to the appellant by discrediting that testimony and referencing that in its order. And I would just respectfully disagree with the court's assessment in that regard, because I think the appellant had the choice to testify at that forfeiture hearing. He did so, but once he did, any inconsistent statements that he made were fair game for the state to rely on in making its affirmative case. And the trial court was well within its right to find that by making inconsistent statements, that completely undermined his claim that this was legitimate business income. And the court's decision was supported by the evidence in the record. It cited several reasons for making that credibility determination. It cited the inconsistent statements that I've already discussed. It mentioned that the appellant claimed all the banks were closed in California because this was during the pandemic, which the trial court found was not accurate. He also claimed that he did not have any banks in California, but the Wells Fargo checking statements reflect that his bank did operate on both the East and the West Coast, so that was not accurate as well. And there were also no large withdrawals reflected on those banking statements that would reflect that the appellant had withdrawn a large amount of cash. That would explain why he had $105,000 in cash. My understanding from the statement of the evidence is that the appellant initially testified that his business income was deposited into that checking account, but then later when he was asked about the lack of withdrawals that could explain this, he then testified that all of this money was actually just from customer tips. And so the trial court additionally relied on that statement at the forfeiture hearing to discredit his testimony. So when the court considers all of these circumstances, we submit that the state easily carried its burden of proving, just by a preponderance of the evidence, that the money that was in the rear cargo area of the Yukon was likely derived from the prior sale or delivery of controlled substances, such as the promethazine with codeine that was in the car at that very moment. If the court has no further questions, we respectfully ask this court to either dismiss the appeal or affirm the trial court's forfeiture order. Thank you.
Thank you. I believe you have 5 minutes.
Thank you, Your Honor.
And before you begin, the appellee has asserted that you waived your appeal by failing to cite the record. What's your position on that?
Your Honor, we have cited the record. Everything that I have referenced so far in my first statement was something that can be found in the current record of this case. All of the evidence that I cited to is in the record. Starting at volume 5, you can find evidence of Mr. Kilenton's banking statements. 5 through 9, you'll see a list of all the evidence as it was enumerated in the first hearing. And that's volume 5 of this record. So everything that I have referenced can be found in the record.
But when you were writing your brief, did you make references to the record so that those things could be found from your arguments in your brief? Whatever you were arguing about, did you refer to the current record?
I understand, Your Honor. The current record contains the prior record, and so in our brief, we reference the enumeration of it in the prior record, but that is contained within the current record. And I would just like to say that after hearing the state's points, that again, nothing has changed and no new evidence has been presented since this court has first heard this forfeiture opinion. The Tennessee Supreme Court has held in a previous forfeiture case, Lettner v. Plummer, that, quote, the Tennessee Supreme Court, that, quote, the finding of cash with a large quantity of controlled substances does not alone satisfy the burden of proof as held in previous unreported cases in this state. The only thing that that the state has pointed to that has been that this court has recognized as evidence of wrongdoing is the $133,000 which was found in the vehicle along with promethazine. But again, even when the court acknowledged that, this court acknowledged it, it stated that the trial court needed to provide a link connecting that fact to some criminal activity on the part of Joni Kilenton that was the source of the seized funds. Further, all of the evidence that the state cites, whether it's the inconsistent statements or the banking information or his testimony about not being able to get into the bank because of COVID, none of that points to any criminal activity.
Well, it's a credibility finding, isn't it?
The trial court is free to find Mr. Kilenton not credible, but finding Mr. Kilenton not credible is not the same thing as the state proving positive evidence of criminal activity on his part.
Well,
and I would...
The court says it appears to the court that $133,429 was seized after being found in a vehicle after a traffic stop. Money was found wrapped and boxed in the vehicle along with illegal drugs. there were inconsistent statements made to law enforcement by the occupants of the vehicle and when the money was seized. Mr. Kilenton claims $104,000 of the cash was his property earned from his business and should be returned. And then he goes on and finds that Mr. Kilenton was not credible. So he cites to some evidence the finding of the drugs and the way the drugs were wrapped. And then he makes a determination that your client's not credible. What else is lacking?
Well, Your Honor, I would point out that the $105,000 was not found, and the trial court admits, in similar but not the same packaging in similar but not the same areas of the vehicle. So this money was found.
We're only
Mr.
talking
Kilenton's-
about this money that was found in this area, right?
Well, there were two different separate packages. There was a package, a smaller package amount of money that was found with the promethazine in the trunk, and then there was Mr. Kilenton's $105,000, which was found in the third row passenger area. I'd
That's
also.
not at issue, is it?
What's that?
What was found in the passenger area?
Just the money, Your Honor. The promethazine was in the trunk. And
And the court specifically addresses how that was packaged and where it was found, correct?
Your Honor, I've
Yeah,
run out of
please,
time.
go ahead and answer.
The court.
I want to be clear, because I don't think the general, as I understood his testimony, the 105,000 was where the drugs were, but what you're saying is that the 105,000 was in the third floor, and the remainder of the funds was in the back where the drugs were.
Yes, Your Honor. Shall I answer your
Sure, go
question,
ahead.
Your Honor?
I'm sorry, I apologize.
It's fine, Your Honor. Yes, the money was found, some of it was found wrapped in the third passenger area. That was Mr. Kilenton's money. And in the trunk of this car was promethazine next to another bundle of cash that was wrapped, not the same.
And that's the money we're talking about, right?
That's not the money Mr. Kilenton is wanting returned.
Oh,
He only
okay.
wants the 105 that was in the third row, Your Honor. He has no knowledge of what was in the trunk of the vehicle.
Thank you, thank you.
Thank you, Your Honor. Nothing further.
All right, gentlemen, we certainly appreciate your argument and your briefs. We will take this matter under advisement and attempt to render an opinion as quickly as possible. Thank you. You may be excused.